When does a trial judge's rulings deprive a defendant of a fair trial? To find out, you have to read People v. Devereaux. But it's 12 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals cases in 5 minutes or less. This is the episode on People v. Devereaux. This can be found at 2022 New York Slip Opinion 03362. I put a link to that case's decision in the description. It was published by the Court of Appeals on May 24th, 2022. It's a criminal case, and it has to do with evidentiary rulings and the constitutional right to a fair trial. And the issue in this case is, did the evidentiary rulings by the judge in this case, precluding a witness and not allowing 911 calls to come in, deprive the defendant of his constitutionally protected right to a fair trial? Three things you have to understand about the law to understand this case is that the defendant, under the 14th Amendment, 14th Amendment, as well as the 6th Amendment, has to be given a meaningful opportunity to present a complete defense. And if he's not given that meaningful opportunity to present a complete defense, then it's not a fair trial, and the conviction gets thrown out. The second thing you have to understand is that with respect to extrinsic evidence, you can call a witness who gives relevant and material evidence, but you can't call a witness just to impeach on a collateral matter. It's not allowed. But you can call a witness to impeach if it's probative of a witness's ability to recall events or to observe events. Then it's not collateral. It's relevant and admissible. Finally, 911 calls, people who call the police, 911 in the middle of an incident, that frequently is hearsay. Hearsay is inadmissible as a general rule. Hearsay is defined as an out-of-court statement being offered in court for the truth of the matter asserted. But there's a lot of exceptions. One of them is present sense impression. If the two elements are made out, which is that the call is made by a person perceiving the event unfolding or right after it, and the content is corroborated by independent evidence establishing the reliability of the contents of the statement, then even though it's hearsay, even though it's an out-of-court statement being offered in court for the truth of the matter asserted, it can be admissible as a present sense impression. Okay, so what are the facts here? The facts here are, at 1:30 in the morning on the streets of the Rockaways, outside of 249 Beach 15th Street in Far Rockaway, there's a group of a bunch of people, including some members of a gang called the 40 Boys Gang, and a person named Granville, and a person named RM. They're all outside of that building. There would have been a party. There's a gathering outside of the building at 1:30 in the morning, and RM sees the defendant and a co-defendant across the street take out their guns and start shooting at the crowd, which included the 40 Boys Gang, and Granville gets shot in the head and killed. While the shooting is happening, people are calling 911 all over the building, and they're saying, this guy just got shot in the head. There's about 15 shots. Some people are whispering because it's going on at the moment, at the very moments that the calls are being made. Ultimately, RM tries to run away, falls down, goes to the hospital because he hurt himself, and he's the one that leads the police to arrest the defendant. He identifies the defendant, and RM's the one who was present at that shooting, who then testifies that it was the defendant who shot Granville, defendant and his friend who were shooting and shot Granville. The defendant gets arrested and he says, justification, I was self-defense. The 40 Boys Gang were shooting me first. It goes to trial, and RM's the only eyewitness who testifies. He says, I was with my girlfriend until just a few seconds before the shooting, and I saw the shooting and I saw the defendant do it. The defendant tries to put on his defense case, and he tries to call the girlfriend, who RM says was with him the whole night, and she would say, according to the defense, I was never there. I wasn't with him that night. The judge doesn't allow it. The defense tries to introduce the 911 calls. The judge does not allow it. The defendant's convicted. It goes to the appellate division. It goes to the Court of Appeals, and the Court of Appeals says this was a deprivation of the defendant's constitutional rights. With respect to the extrinsic evidence, it's not collateral, the Court of Appeals says. It goes to whether or not she was actually there, whether or not RM can properly recall and perceive events. So it's not collateral. It should have been admitted. And with respect to the 911 calls, the Court of Appeals says that was a classic present sense impression. They were describing an event as it unfolded. They were corroborated by the fact there was a dead body shot in the head, by the fact there was 13 gunshots, and they said 15 gunshots approximately. And they said that these errors in evidentiary rulings, these errors by the court in denying the defense those applications for witnesses and for evidence, denied the defendant of his fair opportunity to provide a meaningful defense and prevented him from establishing his justification defense as much as he could. And so they reversed the conviction. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.